No, thank you very much, Chair. And thanks for giving us the opportunity to introduce a private members bill to the Standing Committee on Finance, which is a standing committee of the National Assembly. That is our understanding in terms of how this process is going to proceed. And just to give clarity to what was the caucus or the seekers of the Democratic Alliance now, we must clarify that we as members of parliament individually can introduce legislation which must be deliberated upon, and then once passed by the National Assembly, it goes through the NCOP process, and then it's taken to the president to sign into an act of parliament. And if the president is not happy about its constitutionality, will bring it back to parliament for further deliberations. But also members of parliament individually have got a right and permission to could approach the Constitutional Court to say that whatever is contained in the law that is about to be passed is not consistent with the Constitution. We make that reference in the presentation that we're going to make today here. So the presentation from the beginning, I think that must be clear. We're making it to the Standing Committee on Finance in terms of how it should be in terms of what happens. So we are hereby introducing the South African Reserve Bank Amendment Bill, which will effectively amend the South African Reserve Bank Act number 90 of 1989. So in its current form, the South African Reserve Bank Act allows private individuals, including those who are not resident of South Africa or citizens of South Africa, to own shares of the South African Reserve Bank as shareholders according to the shares that are issued by the South African Reserve Bank and in accordance to the Act. So the private shareholders, through acquired shares in terms of the Act, have got some role to play in the governance of the South African Reserve Bank, including the election of the directors, but also receiving of dividends from the bank's profits. But we want to state clearly here that our presentation today is thematic. It's about the ownership of the South African Reserve Bank, and I appreciate that there are ongoing debates on the role and independence of the South African Reserve Bank. But we're not dealing with that today. We're only dealing with the ownership component. There are, of course, various authentic and sometimes very correct debates on the mandate of the Reserve Bank and its policy direction. And there's absolutely nothing wrong with whoever is making those contributions in terms of the discourse that relates to the Central Bank of South Africa. And as lawmakers, we have got an obligation and a constitutional right to make laws and oversee the executive. So whatever we're doing here is within our constitutional right. And one thing that we must state from the beginning is that there's no law in South Africa that is cast on stone, that from time to time will engage to amend and change the laws and even the Constitution. It's not unconstitutional to amend the Constitution itself in terms of what is the mandate of the Reserve Bank and what is its direction. But today, I emphasize again that we're not dealing with that. We're dealing with the aspect that speaks to the issue of ownership. And of course, we are aware that there are so many things that the Reserve Bank that can do in terms of usage of monetary policy to generate a greater economic activity and therefore jobs. We are aware that the Reserve Bank can play an important role in terms of leading the convergence of the macroeconomic policies in the region, in the entire continent. More so that now we've got a ratified Africa Free Trade Continental Agreement area, which will need central banks in the entire continent to play an important role. I think we've already given a clear perspective in terms of the constitutional context that as the National Assembly, as Parliament, we have got the legislative powers to pass legislations that govern almost every sphere of society. And before we come to the amendments that we are proposing to the South African Reserve Bank Act, we want to just give context as to what is this South African Reserve Bank. So it is a central bank which is a relatively autonomous financial institution with the monopoly to control the production and distribution of money. It accounts to Parliament. It is currently owned by private individuals. Its role in terms of the constitution is to protect the value of the currency in the interest of balanced and sustainable economic growth. But in terms of the Financial Sector Regulation Act, which came into effect in 2017, but majority of its aspect operationalized from 2018 forward, the South African Reserve Bank has got an obligation to maintain, promote, and enhance financial stability in South Africa. It is one of the about 9 central banks that have got still private shareholders. The rest of the central banks in the world, more than 240 of those, are state-owned, are owned by governments. And that is why we're coming here to say that we think that it is basic logic, it's basic necessity, it's superior logic that we must have a central bank that is owned by the state. And it has got 2 million shares that have been issued out. And majority, if not all of them, charged at 10 rands. So whoever owns the Central Bank of South Africa today, like if you collectivize the amounts of money that has been paid there, doesn't exceed 21 million rands. And I'll give context of what is the importance of emphasizing that. And in terms of the dividend distribution, whenever the central bank has made profits, is that all the profits, even if it's 1.2 or 5 billion rands profits, which the central bank makes out of its dealings with a variety of other business activities, it can only distribute 10 cents per share, which is maximum of 200,000 per year per share in terms of all the shareholders. And in terms of its current architecture and design, there is no single shareholder in the Reserve Bank who can hold more than 10,000 shares, meaning that there is not a single person who can receive shares of more than 1,000 rands on an annual basis. That is what happens. And then the shares and the dividend that remains are then deposited into the National Revenue Fund, into government, after the Reserve Bank had settled its own operational expenses and set aside the contingents and reserves and tax obligations that obliges the central bank. That is what it then deals with. And what is the role of the Reserve Bank? It issues banknotes and coins. It prints money. It regulates and supervises financial institutions, particularly banks and the insurance companies and a variety of other role players in the financial sector. It is the one that permits and licenses banks and insurance companies to exist. So there is no bank that exists in South Africa or an insurance company without the permission of the South African Reserve Bank through its Prudential Authority, which is one of the most important components there. And then of course we'll highlight what are the challenges of that. But it also ensures the effective functioning of the national payment system. It manages the official gold and foreign exchange reserves of the country. It administers the country's remaining exchange control regulations. It is the banker of the South African government. But also, additional to some of the resolutions that were taken in the past, the South African Reserve Bank currently owns 50% of African Bank, an anomaly which, when we have the other discussion about the creation of a state bank, will then deal with that. You cannot be a regulator and a licensor and still be a shareholder of a bank in the manner that the South African Reserve Bank is. And what have been the realities that define the South African Reserve Bank thus far? It presides over one of the most untransformed sectors of the economy in South Africa, which is the financial sector. And of course, I had already indicated that that includes the insurance companies and the banks. And that is what it is. And we know that the banks and insurance companies, majority of them are owned by the white capitalist establishment. So the ownership and control of the banks and the insurance companies does not reflect the demographics of South Africa. And we would know that in South Africa, we still have highest levels of bank ownership and control concentration, with 90% or more of the bank assets being concentrated in 5 of the top South African banks in terms of what happens. But also, the South African Reserve Bank presides over one of the most sophisticated multinational illicit financial flows, tax avoidance and base erosion. And that is what defines the bank in terms of what happens. But also our observation, and I will give you a context when we then come to the legislative amendments of what we mean by this, that it largely had been inactive, and it has been toothless because it did not do anything when the banks which it regulates were involved in fixing of the currencies. It led the Competition Commission to be the one that deals with that, whilst they've got the responsibility and obligation to then deal with that aspect. So by and large, the Reserve Bank is responsible for the reproduction of the apartheid economic and financial inequalities in the manner that it is. What is the problem? The problem is one that is observed by, of course, a liberal. It's unfortunate to quote a liberal Prime Minister of Canada in 1935, who said that once a nation parts with the control of its currency and credit, it matters not who makes the nation's laws. Usually, once in control, will wreck any nation until you control the issue of currency and credit is restored to government and recognized as the most sacred responsibility. All talk of sovereignty of parliament and of a democracy is idle and futile. But also one of the most dangerous but very powerful families in the world, the Rothschild, said in their own admission that permit me to issue and control the money of a nation, and I cannot who makes the laws. That is what it is all about. And we have got a situation in South Africa where a significant number of the shareholders of our central bank are not the people of South Africa, and majority are white people, and we know where that come from. And that is basically what it is, that we have a situation that the owners of the central bank do not reflect the demographics of South Africa. And our proposal, the legislation that we're proposing here, is to take the shares, the owners of the Reserve Bank, from the 800 odd private shareholders to 57 million South Africans. That is what we're proposing, that we must change the law in terms of what happens. But also the cornerstone of the ownership and control of the state by the white capitalist establishment has always been the financial sector, has always been the cornerstone of the financial sector through formal and informal influence of the South African Reserve Bank. Leading officials in the financial systems of the country have always been appointed by the capitalist establishment, which is predominantly white, and ownership and shareholding of the SRIB is legitimated through these appointments. And oversight over these private banks, whom through proxies and networks of complex and often illicit ownership is weakened. We have witnessed these as the bank fails to deal with aggressive illicit financial flows and corruption facilitated by the banks. Even when banks are engaged in currency manipulations, which majority of them have admitted the central banks has failed to act much more decisively. What is the state of central bank ownership globally? There's about 240 central banks that are owned by different owners all over the world. And an absolute majority of central banks are owned by the state as a sole owner, or sometimes with a combination of some private shareholders, in terms of what got to happen. And in post-colonial states, more so after the First and more so after the Second World War, a lot of central banks were transferred to the ownership of the state in the manner in which it is. There's only 9 out of the 240 central banks that have got private shareholders in the whole world, where and it's not wholly ownership by the private sector. In Belgium, 50% is owned by private individuals, 50% is owned by the state. In Greece, the state owns 35%. In Italy, the state has got no ownership of the central bank. In Japan, the state owns 65%. In San Marino, the state owns 67%. In Switzerland, the state owns 51% of the central bank. In Turkey, the state owns 51%. In the United States, the state owns at a federal level 0%. In South Africa, at all levels, the state has got no ownership and control over the central bank. And that is an issue that we must then deal with. And in terms of the legislation that we have tabled, we have set out basically 3 objectives which are properly articulated in the legislation that is amended and has been availed to all members of parliament who are responsible enough to read, that we are intending to make the state the sole shareholder of the shares of the South African Reserve Bank, and that we must provide for the appointment of the board of directors, the tenure of the office of the appointed directors, and give the minister the power to make regulations related to the appointment of appointed directors. And we must always state that whoever is an elected minister will be doing so on behalf of a democratically elected government, therefore on behalf of the people of South Africa. But also from a technical point of view, that the minister must be given the power to appoint the auditors of the central bank. And specifically, Chair, I'm about to conclude, you'll see now very soon, that the sections that we are proposing must be amended. One is Section 4 of the Act, that the current sections provide for shareholders to elect 7 directors of the South African Reserve Bank. So the 13 directors of the South African Reserve Bank and 7 are appointed by these private shareholders. I will explain who those people are when we are going to the conclusion. And our proposed amendment seeks to empower the minister to appoint the directors of the board and to provide for how the nominations of those directors will be done. And then we're also then dealing with Section 4A of the Act. The current sections provide for submissions of annual financial statements of the bank to be submitted to shareholders. The proposed amendment seeks to provide for annual financial statements to be submitted to the Minister of Finance and Parliament. And then Section 5, 6, and 9 of the Act. The current sections provide tenure and conditions of office of directors elected by shareholders, filling of vacancies, and validity of board decisions. The proposed amendments seek to align the appointment process of the board of directors in line with the state proposal that the state be the sole shareholder of shares of the South African Reserve Bank. And then Section 10 of the Act, we are proposing that there must be an amendment that the current section provides for the bank to form shares. The proposed amendment seeks to remove the power of the bank to form shares, as it will be owned by the state. And then we are also proposing an amendment to Section 13 of the Act. The current sections provide for prohibited business that the bank may not engage in. The proposed amendment seeks to remove those prohibitions in line with the proposals to make the state the sole shareholder of all the shares of the bank. And then the section, as it is now, section 13, becomes inconsequential in terms of its provisions. And then section 21 of the current act, the current provision provides for the bank to have shares capital of 2 million rand, dividend into 2 million ordinary shares of 1 each rand. The proposed amendments makes the state of the sole holder of shares in the bank and proposes that the rights attached to those shares be exercised by the Minister of Finance on behalf of the state. But we also then deal with section 30 of the existing South African Reserve Bank Act, that the current sections provide for the shareholders to elect 2 firms of public accountants to act during that year as auditors of the bank. The proposed amendment seeks to empower the minister to appoint firms of public accountants to act as auditors of the bank. Then section 32 and 33 of the Act. The current sections provide for the bank to submit list of shareholders and number of shares held by each shareholder. These sections becomes inconsequential in line with the proposal of the state as a sole shareholder of the bank in terms of what should happen. And what we aim to achieve through a state-owned central bank. The South African Reserve Bank is one of the apex of the financial system in South Africa, and it should be democratically owned by the people as a whole. And if all of us admit that a democratically elected government is a government that belongs to all the people, it must have the right to own a central bank, not a group of individual people in terms of what should happen. But also from a policy perspective, one which we'll deliberate on from time to time is that a state-owned central bank should deal decisively with the concentration of ownership and control in the banking and insurance sector in South Africa. That is one of the issues that we must be unapologetic about in terms of what should happen. It cannot be correct that South Africa, with a population of indigenous people, majority, 80% almost, have got no access to ownership of their own central banks, whilst 90% of countries in the world are owning their own central banks in terms of what happens. Who are these current shareholders whom we want to take the bank from and give to the ownership and control of 57 million South Africans? There's about 802 shareholders of the South African Reserve Bank, and we're saying that let us take from those 800 odd people the bank and give it to 57 million South Africans. And the shareholders of the South African Reserve Bank currently, in terms of the register of the shareholders of the South African Reserve Bank, includes the sitting Minister of Finance, Mr. Tito Mboweni. He has got shares of 10,000 shares. The DA Shadow Minister of Finance, Georgine Hill-Lewis, has got, paltry shares of 10 shares in the South African Reserve Bank. Maybe that is why he is not part of this meeting today, because he knows we're going to be discussing expropriation of the shares from him and give it to the people. It includes the Anton Rupert Trust. It includes the shareholders currently includes Absa Bank Limited, Discovery Limited, which is part of the Remgro Criminal Syndicate, First Rand Bank Limited, which is part of the Remgro Criminal Syndicate. It includes Nedco Limited, which is part of Old Mutual ownership patterns of Trevor Manuel. But it also includes owners from Australia, from Switzerland, from Germany, from the United Kingdom, from Norway, admittedly from Zimbabwe, from Namibia as well. And that is what in terms of what happens. And admittedly, Chair, there is no massive financial benefits that accrue to the current shareholders of the South African Reserve Bank. So there will never be a sound claim for any compensation that will be unreasonable when we take over the Reserve Bank to state ownership in terms of what should happen. Now, our concrete proposal is that for public purposes and in public interests, which is provided for in Section 25 of the Constitution, we should take the shares of all these owners without compensation. There's no need to do so. It is not going to have any wrong impact. Now, in conclusion, let us dismiss the myths and urban legends that are associated with the nationalization of the South African Reserve Bank. So a lot of right-wing opponents of the nationalization of the Reserve Bank says that it is going to cost South African government billions of rands to nationalize the South African Reserve Bank. That is not the case, because currently each of the 2 million shares is 10 rand, meaning that in total the shares issued by the South African Reserve Bank is 20 million rand, meaning that no one has paid billions to gain shares of the South African Reserve Bank. It's just a vanity affair which we must abolish now in the interest of the people. So there is no one rationally who can go and claim billions of rands from anywhere in terms of the nationalization of the Reserve Bank. But also the highest dividend paid to each shareholder annually is not above 1,000 rand. So the people who own like 10,000 shares, which is about 0.5% of the Reserve Bank, they never ever receive more than 1,000 rands as dividends. On what basis are they going to go to court and claim billions of all the assets that belong to the Reserve Bank on the basis that we have taken a correct, properly, politically, morally justifiable decision to have state ownership of the bank? We need to take over the ownership of the Reserve Bank to guarantee true sovereignty and autonomy of our country and parliament in terms of what should happen. And of course, from there on, we'll debate the issue of the mandate of the Reserve Bank and all these issues. Today's discussion is not about the mandate, the role. It's not about how do we use monetary policy to achieve maximal employment, like is the case with many other central banks. Today, we're discussing the ownership component, that there is no necessity, there's no need for private individuals to continue owning private shares in the Reserve Bank. Chair, it is true that what we gained in 1994 of the so-called democratic elections was just transfer of political power, whilst economic power and control remain in the hands of few people. Today, we are presenting an important legislative milestone in the journey that will transform South Africa's economy. Thank you very much. You can see the chairperson. I take in bank.
Honorable Shibambu, that's the presentation.